Welcome to our second video in the series about the criminal case process. And this video is going to be all about the pretrial hearing. Now, many people get nervous when they hear the term pretrial hearing. They think that the trial must be coming up fast, like the very next court date, but nothing could be further from the truth. The pretrial hearing is simply a date at the very beginning of the process, which can take several months. So stay tuned to learn what you need to do, what your lawyer is going to do, and what the prosecutor is required to do at the pretrial hearing. All right, before we get too deep into what's going to happen at the pretrial hearing, I wanted to go over one other thing first. Let's not get too caught up in the names of these types of hearings. Along the way, you're going to hear the fancy names for these hearings. You heard about the arraignment, pretrial hearing, compliance and election date, trial readiness conference. What's worse is you might even hear about some of the acronyms. So PTH, CNE, TRC. Let's not get too caught up in these, okay? For the most part, all of these dates are simply status dates. Replace in your mind the fancy name of the particular date with status date. Okay, it's going to make it a lot less complicated for you along the way. All right, now that we replaced the term pretrial hearing and these other dates with status date, it's important to know what these status dates are for. Essentially, what these status dates are for your lawyer and the prosecutor to get together and to start to determine the direction the case is going to go in and what each side needs to give to the other. We call this the discovery phase. And unlike what you might have seen on TV, there's not supposed to be any surprises in a criminal case. Both sides are required to share with the other certain evidence they intend to use at trial, the names of witnesses, and other things that could both be helpful to your case as well as harmful to your case. Believe it or not, the prosecutor, if they know about it and if they have this particular evidence, are even required to give you items that might hurt their own case. We call it exculpatory evidence. Okay. So stay tuned to learn a little bit more about what those types of evidence might look like and what your lawyer is going to do to get them. All right. Part of the reason I like to refer to the pretrial hearing date as a status date is that most of the work happens prior to you even getting to court on that date. The time you're going to actually spend before the judge at your pretrial hearing date is going to be somewhere between 30 to 45 seconds. You're not going to say anything. Your lawyer is going to do a little bit of talking about what they've talked about with the DA, and then they're going to pick the next status date. So, why do we even have this date? I've asked myself that many times. More particularly, why do you have to go to this date? Because you're not saying anything. You are literally just standing there. And this is also why many courts are allowing clients, defendants to come in via Zoom or sometimes having the lawyer waive their appearance altogether. Because for the most part, their participation isn't all that required. Like I said, most of the work for the pretrial hearing actually happens before. So after your arraignment, you're going to get some information, police report, maybe your client's record, some other things, and this the lawyer is going to start to go through those things, and your lawyer should go through these things with you because you might have some input about some things that are going to be needed. And the lawyer starts to develop a plan about what direction they want the case to go in. The first thing the lawyer is going to do is to scan through those documents, particularly the police report, and help to understand what the evidence might be, what they might be for evidence. Okay. So, for instance, are there other witnesses other than the police, civilian witnesses, we call them, right? Do we need to get more information on them? Are there other types of evidence? Is there a 911 call? Are there photographs? Is there what they call a cruiser mounted camera or body worn camera evidence? Is there some type of scientific evidence like a blood test or a breathalyzer test, or potentially in certain cases, it might be DNA testing? Other things we might consider as we enter the pretrial hearing is, are there other defenses that we might raise on your behalf? Are there motions that we could file to dismiss the case or to potentially what we call suppress certain evidence or keep that evidence from ever being heard by a judge or jury at trial? Are there other defenses such as self-defense or an alibi defense or potentially what we call a criminal responsibility or insanity defense? Now, all of these things, like I said, are done in the days and weeks leading up to the pretrial hearing. These are all things your lawyer is starting to think about and strategize to figure out what's going to happen with the case and what direction the case is going to go in. Now, your lawyer should be communicating with you during this period of time and trying to ascertain what information you might be able to give to help with those defenses. And this is part of what you guys are going to be doing as you head into the pretrial hearing date. But like I said, on the date of the pretrial hearing, your role is very limited. You're going to show up to court if you're required to be there, and you're not going to say anything. Your lawyer's going to have a brief conference with the prosecutor. Sometimes we have the ability to speak to them in the days leading up to it as well. There'll be some paperwork filled out, and then they're going to go before the judge. They're going to talk about what might be outstanding for discovery, what the Commonwealth is still required to give the defense, and in some cases, what the defense is required to give the prosecution. Maybe state a very brief statement about what direction the case might be going in, if the defense intends to file any certain motions, things like that. The defense has the ability on this date to also file discovery motions, although that is less common these days simply because there's so much discovery that's automatically given to us. Once the judge is done talking to your lawyer and the prosecutor about what direction the case is going in, your lawyer will schedule a further court date. This will be about 4 to 6 weeks out. We call this date a compliance and election date. We're going to talk more about this compliance and election date in the next video. So stay tuned to this series about the criminal case process to learn more about what happens at that date, the compliance and election date.